We're following a big update in a shocking case of child sex abuse. This former nurse was caught by her husband having sex with her stepson. Alexis Von Yates made a shocking excuse when trying to explain herself when her husband walked in on the incident last summer. She has now taken a plea deal. What that means for how long she'll be in prison. We're on the case presented by Law&Crime. I'm Chris Stewart. The police report that we have in this case, I will be honest with you, is not an easy read. It details a stepmom having sex with her 15-year-old stepson, then trying to make excuses when she's caught. And let me tell you, there is a lot that was included in this police report that I cannot say, and frankly, I don't want to say. But it is important that we rehash what police say happened the night this then registered nurse seduced a minor inside her home, her own stepson, before we get to the plea deal that she just took. Here's a picture of Alexis Von Yates. She was 34 years old when all of this went down last year inside her home in Ocala, Florida. She lived with her husband, who had a 15-year-old stepson who was staying at their house for the summer on vacation. He had stayed with them for roughly a month. Police say on one of the final nights that the boy was staying at the house, he was hanging out with his stepmom. They were watching a horror movie on the couch. Now, the two had just put the younger children in the home to bed. It was around 11 o'clock at night. Police say Von Yates and her stepson were also hitting a THC pen. The two apparently found the movie Terrifier 2 boring, according to the interview that the victim in this case gave police. And that's when this police report states that Alexis Von Yates started talking about how aroused she was because she hadn't had sex in a couple of weeks. Again, this is a conversation with her 15-year-old stepson. In the interview that the stepson then gave to police, he said he was sitting close on the couch with his stepmom and he was playing with her hair. Now, apparently, Von Yates making these kind of statements didn't come out of the blue. The teen told investigators that his stepmom had been making sexual comments for roughly a week. He said he went to the gym with Von Yates, and when they got into the car after, she said, quote, "I bet everyone thought you were my little boy toy." In another instance, he said Von Yates was eating whipped cream and she stuck out her tongue in a way that the victim found sexual, and he likened it to what you see in a pornography film. And Von Yates then reportedly said, quote, "Oh, you like that." Then there was reportedly an instance where he was on a golf cart with Von Yates and two of her friends, and he also said that this 15-year-old, he was given a shot and also another hit of a THC pen. The teen said that he did make some sort of sexual joke, and then Von Yates said to her friends, quote, "He probably watches those stepmom pornos." Now, on the night where Von Yates had sex with this teenager, the police report states that after Von Yates had talked about how aroused she was, the teen asked if they wanted to cuddle. The police report states that the teen told them that Von Yates at first said that would be, quote, "weird." But then, when the teen laid on top of Von Yates, she said something to the effect of, quote, "Oh, you're just going right for it, huh?" Now, police then say, as the teen kissed Von Yates on her neck, she escalated the situation by saying, "Ah, man, I wish you were 18 because you're not old enough." Police say the child victim then gave Von Yates oral sex. The police report goes on to say that Von Yates told the teen to stop, but then would pull him back in to continue. Von Yates then gave the 15-year-old oral sex and said something to the effect of it was the least she could do. Now, as this was going on, the door opened to the home and in walks that 15-year-old's dad, who was Alexis Von Yates' husband. He was a lineman. He worked late nights and he had come home. And at that point, the police report says that Von Yates and the boy were in the middle of having sex on the couch, which was directly near the front door. Now, when the boy's dad walked in, he says he saw the 15-year-old run to the bathroom and Von Yates was shirtless on the couch. The teen then said in this interview, the dad said something to the effect of, "What the expletive is going on?" He then pulled the blanket off Von Yates and saw his wife naked. Now, the boy's dad then ordered the teen to pack his things and leave the house. The teen says that he also heard his dad calling Von Yates, his wife, quote, "a child predator." And this is where Von Yates makes an excuse that you will not believe. Von Yates says to the dad reportedly, quote, "The child victim looks like his father when he was younger." That's according to this police report. Von Yates also claimed that she told the teen to stop, which based on the police report and all those details, she may have said that, but much of that statement is a lie. The next part of this story and what the teen said in his interview lays out how his family handled this situation, and they handled it in a way a lot of people would say would be the wrong way, but then things come around later. I'll get into that. The boy and his dad left the house to drive to the boy's grandfather's house, the teen said. And on the way, the boy's dad actually stopped at a gas station. He picked up a six-pack of beer, and the teen said his dad chugged it as they drove. The boy's dad then told him to never talk to him again. He also called the boy a, quote, failure. The boy's grandfather said, quote, you better not be telling them what happened, when the boy said he was going to talk to his cousin about this. He also told the boy not to contact his mom about what happened with Alexis Von Yates. The boy told the interviewer that he was infatuated with Von Yates, and he had never actually engaged in sexual or emotional activity before. But he also felt upset that his family, in his opinion, was trying to cover up what happened. But Von Yates wasn't done. The teen said the next morning, the boy called her after everything that had happened, even her husband walking in on this situation, according to the police report. And on the phone, Von Yates said how she wished that her husband hadn't walked in on them, and she also made more sexual comments. She even rated the experience, the teen said, a 7 out of 10. I put Alexis Von Yates' name into truthfinder.com and putting this episode together, and in the section that shows whether someone has a criminal history, you can see that her record did come up. At Law&Crime, we partner with Truthfinder, and we use it to get details on the people involved in our stories. Now, even if you don't work in true crime though, this can be a great tool to give you some peace of mind, as it's one of the largest public record search services in the United States. And with the paid subscription service, you get access to unlimited reports about almost anyone. And right now, you can get 50% off your first month of confidential background reports. Just go to truthfinder.com/OTC. Now, police say an anonymous tip was put in about this case that then brought it even more to light. And that tip, according to a witness known as Kaylee in this police report, was reportedly put in by the boy's dad. So it appears that there's a bit of a change of heart, maybe a cooling off period, after the teen said his dad allegedly tried to cover it all up and have it go away the night that he walked in on all of this happening. According to that witness, the boy's dad did have that change of attitude from the narrative that police had put out the night in question. The dad said he was on the stepson's side as long as the stepson was willing to testify. Now, police say when Von Yates was contacted, she said she did not want to speak about it unless a lawyer was present. And also, according to this police report, she thought a DCF case against her had been closed and that she was in the clear. Police say she even continued to blame the victim in this case, that 15-year-old boy. In April of this year, the state of Florida suspended Von Yates' license to practice nursing. She had been a nurse since 2016. And with how detailed this police report was, you can see the case that prosecutors would have had against her in a trial. In May of this year, a court ruled that all those details I gave you, there is more in that police report that I just couldn't go into detail about because it's so graphic, but all of it was going to be admissible if this case had gone to trial. And that was a major blow to Alexis Von Yates' defense. Court records show on August 21st, so last week, Von Yates pleaded no contest to a charge of lewd and lascivious battery, and that was part of a plea deal. She originally was facing a charge of sexual battery on a minor. The Daily Mail reports that Von Yates will spend 2 years in prison, then have 2 years of community control, and then will have 10 years of sex offender probation. She will also have to complete 200 hours of community service. She will be sentenced on September 16th. Joining us now, criminal defense attorney Joe Tamburino. Thank you for being with us on Law&Crime. Tough story here. I mean, just the details of the affidavit when she was arrested, the interview that the victim gave in this case, very detailed to say the least. When you look at, now that she's taken this plea deal, if she were to go to trial, how defensible of a case was this for her?
Well, thanks for having me on, Chris. Not defensible at all. I mean, she got a very good deal in this case, and here's why. In Florida, the age of consent is 18. There are exceptions if the person is 16 or 17 and the person they have sexual relations is no more than 23 years of age. However, she was originally charged with basically what's called a first-degree sex crime, which goes up to life in prison in Florida. And what that means is that if you have sex with a family member, specifically who's underage, you can get up to life in prison. However, she was able, through her attorneys, to work out a very good deal, which means instead of facing all of that, lifetime registration, everything along those lines, she's going to get 2 years and then no more than 10 years as a sex offender registrant. So it's not a bad deal for her.
Yeah, are you surprised by how good a deal that is? Because on one hand, I could see if you're prosecutors, if you have a victim who really does not want to testify in court, wants this to go over, but then at the same time, you go through the details and that interview that the victim gave, like all those details were going to be included in this trial. It seemed like they had her in a lot of ways, and that it'd be a tough case, like to your point, I mean, it'd be a tough case to win for a defense attorney. Why would prosecutors give such a favorable deal?
Because the victim and the victim's family wants it. Just because you have an excellent case as a prosecutor, and just because you think there's a 99.9% chance that you're going to get a conviction, doesn't necessarily mean that you will go to trial, because a lot depends upon the victim and the victim's family. If you have a victim that says, look, I understand you got a great case. I understand you could convict this defendant, but I don't want to go to trial. I don't want to get up on that stand. I don't want to talk about what happened to me personally. So please give the defendant a deal that they can all live with. So even though, as a prosecutor, you have a very strong case, you still have to factor in the victim. All states, including Florida, have victim rights statutes, meaning victim right laws. And part of that is, though the victim can't dictate what a plea bargain is or dictate whether to go to trial or not, you still must take consideration of their requests, their beliefs, their opinions.
She ends up pleading to lewd and lascivious behavior, I believe. She was originally charged with second-degree battery. What is the difference between the two?
Well, right off the bat, battery means that you actually committed an assault and you had no consent to do it, meaning that you had sex or sexual contact with someone and they couldn't consent because of their age or in some situations because of infirmities. Additionally, you could receive a lot more penalties if you went to trial on a battery. With lewd and lascivious, I believe the maximum penalty there is 10 or 15 years in Florida, and she gets a guarantee that she's not going to serve any more than 2 years. So, what she could have gotten at trial upon conviction is quite differently than what she's getting with this plea bargain.
There's still a sentencing that's going to happen, so the judge will have to sign off on this plea deal. On one hand, you're going to have, I've read that the victim is planning to give a witness impact statement. For her, I mean, how, if you were her counsel, knowing how good a deal this is and what it could have been, how important is it that she gives a statement in front of this judge to make sure that a judge would actually accept this deal?
I don't think she's going to give a statement. She could. It's her right of elocution. There's no doubt about it. She could. But she pled no contest to this. No contest means, hey, judge, I'm not saying I'm actually guilty, but I still want to plead guilty. I accept everything that would make me guilty in this case. In those situations, most of the time, a defendant will simply tell the court that the defendant appreciates the court time, is very sorry for all of this, and wishes for the court to accept the plea. I don't think she's going to say more than that. Really, what could she say other than she's very sorry, she's amenable to treatment, and she's going to better her life. But I would be surprised if she actually gives a full statement.
Because what typically happens, and this is more just a side to her story in particular, but we have seen those cases where a deal's brought forward and you just see a judge that says this isn't going to cut it. What typically happens in those cases where a judge, even if it's a really good deal and the public could say, how is this person only getting this much? Typically, what needs to happen for a judge to intervene and say that this isn't something the court's going to accept?
Well, in most situations, a deal that a prosecutor strikes with a defense or a defense attorney has to be approved by a judge because the judge doesn't have to accept a plea bargain. In fact, you will see throughout the country, sometimes judges will say, look, I know the parties have this agreement, but I'm not going to accept this agreement. I, as the judge, I don't have to. I think this is too lenient or too whatever the objection is. Now, most of the time, judges will accept agreements between the parties. Why? Because you obviously have competent counsel on each side, and clearly they've litigated the case. They know more about the case than the judge does. So many times the judge will simply trust the decision that the prosecutor and defense attorney has made. However, yes, in this case, it's possible, though I think unlikely, that a judge would say, I'm simply not going to accept that.
Now, as a criminal defense attorney, I mean, I'm sure there's days that are easier than others. But if you had to defend Alexis Von Yates, and you see all the details that this victim put forward in an interview, that they tried to get that excluded, but it was going to be admissible in court. If this had gone to trial, what would the strategy have been if you were the defense attorney for her?
Well, the only strategy would be to try to impeach the victim in the case, because the victim would have to testify and you would have to try to attack their credibility. However, in cases like this, that's very difficult. When a defense attorney, especially an experienced defense attorney, has a case like this, sure, you do whatever type of legal defenses you have at your disposal. You challenge the admissibility of evidence. You challenge the admissibility of statements. You challenge a number of things. But at the end, when you don't prevail on those, then you go into some type of settlement mode. Because in the end, you have to do what's best for your client. And in a case like this, after you've litigated all of your issues, what's likely best for your client is some type of negotiation. And considering all the factors, at least that we know in the public realm about this case, the negotiation is beneficial to the defendant.
Because it seemed like, just based off the affidavit and the statements that she even made, according to police when they contacted them, she was doing a lot of, well, the 15-year-old, he was consensual with this, though he was, I mean, again, only 15 years old. A lot of victim blaming, which I know is a term that's thrown out there a lot. And that's, I think as a defense attorney, sometimes you have to really, as you're saying, go at the victim in a lot of ways. How effective, though, can that be, knowing that there could be jurors sensitive to the fact that in Florida, I mean, 15 years old is not an age of consent?
Well, you're exactly right. 15 years old is not an age of consent. Like I said earlier, there are some exceptions if the alleged victim is 16 or 17 and the alleged perpetrator is less than 23 years of age and there's evidence of a relationship. Yes, there are those exceptions. But the two biggest hurdles for the defense in this case is, number one, this is basically a familial relationship. This is basically her stepson. So that is going to be a problem. Next is that the alleged victim is less than 16 years of age, which means that consent's not even an issue. Now, when you get to trial, sure, you're still going to try to attack the victim. You're going to try to attack the victim's credibility. And I would imagine that was part of the consideration in arriving at a plea negotiation. I would imagine that when the prosecutor sits down with the victim and the victim's family members, the dad, they explain to them, look, we can try to protect the victim as much as possible in court, but the defense has a right to have a fair trial. And part of that is what's called the Sixth Amendment constitutional right to confront your accuser, which means that even if the accuser is 15 years old, you can still try to confront them. You can still try to show that they are lying or they are mistaken. It's called impeachment. You're still allowed to impeach the person. And I'm sure all of that was part of the consideration in arriving at a plea negotiation.
And there's so many details of this story, from when it first broke to even just kind of rehashing it now that she's taken the plea deal. I mean, this was a 15-year-old boy. She's his stepmom. But then when you think about age of consent, I mean, in Florida, it seems pretty clear, under 18, this cannot happen. If this case had happened in certain states, would this have been actually legal?
No, I don't know of a state where it would be legal because of the familial relationship as well as the age. Most states have age of consents at either 16, 17, or 18. I would imagine there are a few states where it might go lower than that, depending upon the age of the other person. For instance, you can have situations where a 15-year-old and another 15-year-old in some states that can engage in sexual contact without violating any laws. But for the most part, rule of thumb, when you have someone who's, say, 25 years old and someone who's 15, that's going to be illegal.
What is the conversation like with your client? Because I imagine that there's a moment where even if they believe that they're innocent, I mean, she just from some of the statements really felt that the 15-year-old was responsible for this, and clearly the law says that that's not, something that can be a strong defense for you. But I mean, the conversation, what is it like when someone takes a plea? They know they're going to go to prison. As a defense attorney, how do you have that conversation with your client?
Well, the first thing you do is you go over the evidence that's going to be used against your client at trial. After you've contested any legal issues that you have, you've tried to suppress the evidence. After you've done all of that, you sit down with your client and you say, look, all of this evidence is coming into trial and it's going to be very damaging. In fact, we don't have any legal defenses to that evidence, which means if we go to trial, there will likely be a conviction, at least for some of these charges. And if there are any convictions for these charges, you will face X, Y, and Z in prison. Now, we could try to use some of your statements, but some of your statements aren't helpful, such as the victim blaming, such as actually admitting if a person admits to part of the offense. So you do that, and this might take a number of conversations, but you do that and you work with your client so that in the end you say, I think we should try to negotiate this case. And then you go through what would be the parameters of the negotiation.
It takes a lot of guts for a victim to get on the stand, especially with, the defendant sitting there in court, not far away from them. I know you've probably been in a lot of situations like that. It seems like many of these cases will often go to a plea deal because you have a victim, and certainly no shame in it, like not being able to go and testify in a courtroom. I mean, is there a way to get a conviction in some of these cases without having the victim go on the stand and have to really talk about very difficult details right in front of the person they're accusing?
Not really. There are some evidentiary exceptions, but most do not apply when you have something like this, which is where you have an alleged victim who is talking to the police with knowledge that likely this will result in a prosecution of the suspect, now defendant. In that case, the defendant has pretty much an airtight right to confront the accuser. I mean, one of the things that makes our system of justice in the United States so unique and so legally beneficial to all of us in society is that we have a right to confront our accuser. Because think of it this way: if you didn't have a right to confront your accuser, I mean, then a trial would basically be one police officer getting on the stand saying, hey, I tell you why this person's guilty. I talked to these 10 people and they told me this, and this. Those 10 people aren't here to testify, but I'm going to tell you that's what they're going to say. I mean, that's not a trial. That's not a fair trial for sure. So, because of our constitutional right to confront the accuser, to confront a witness, yes, 90% of the time you're going to be able to do that. Now, in many situations, sure, it could be uncomfortable, but there's many aspects of our legal system that are uncomfortable.
No, very, very true. Very difficult story out of Florida. A lot of details in that affidavit. Not an easy read by any means. Criminal defense attorney Joe Tamburino, it's great to have you on Law and Crime. Thanks for helping us break all this down. We appreciate it.
Thank you for having me on.
That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.